Ladies and gentlemen, it's my great pleasure and a privilege to address you today, and I am thankful to the organizers to invite me. And I will try to, as much as it is possible, to give some small review about the codification processes in Serbia in 20 minutes. But let's check whether this is working. Yes, exactly. But let us take a glance first at the history, only on one or two slides, because it is very important to understand the state we have today. There is something which I call the so-called Yugoslav tradition. Today we are talking about different civil codes, different way of codificating civil law in a single body of a code. And there is another tradition which connects us still, is that we do not have a civil code. So actually I cannot formulate my subject very precisely because I'm talking about something which does not exist at the moment. And how is it possible that we do not have a civil code, and why it is part of the so-called Yugoslav tradition? And if we analyze the 20th century, then we can divide it to two phases. I shortly describe the first phase as the so-called first Yugoslavia, between the two world wars, and the second Yugoslavia after the Second World War. There were many countries with many different names, but for the sake of simplicity, it's perfectly enough to name them as such. In the first Yugoslavia, there was something we usually call legal particularism. All territories that joined the common state retained their own rules of law, retained their own sources of law. And that resulted in a very diverse and rich fruit salad, where everyone could find something fitting his or her taste. So ranging from the Austrian ABGB in two different versions before and after the Tajnovellen, the Serbian Civil Code, the Montenegrin Property Code, General Property Code, and including also the so-called, at least we name it so in the Yugoslav literature, the traditional Hungarian judge-made law remained in force. What is more interesting, the Hungarian judge-made law remained to be developed in Yugoslavia. The Supreme Court of Yugoslavia established a special department in Novi Sad, Department B, which continued to develop the case law inherited from the period before. So there was a great tradition of having some form of civil law legislation or having some form of civil code, yet we reached the Second World War without any tangible result of this process, without any unified civil code for the whole territory. After the Second World War, why was that so? Because I think there was a lack of genuine political will to adopt a civil code. We reached the closest point we reached that to enact a civil code before the Second World War was 1934, when a preliminary draft was published, but it was not enacted eventually. After the Second World War, there was again a genuine will to adopt a civil code, and the closest point we got in that process was the end of the 60s, beginning of the 70s, when the drafts of all parts of the civil code were prepared, and there was a will to unify them into a single text. Unfortunately, the constitutional amendments from 71 and the new constitution from 74 made these dreams impossible to realize, and the dream of having a civil code for the entire country, for any of the Yugoslavias, finally disappeared. There is something more interesting, and I'm very grateful to Professor Veres for his help and assistance. He paved the way for this introduction very efficiently. There is a logic riddle which is quite easy for us to solve from this region, but from our esteemed guests from other countries, it might not be clear-cut or straightforward at first glance. If I formulate a sentence, as you see in the presentation, in variation 1, there is no civil code applicable in Serbia, well, that's true. I cannot deny it. But if I say the exact opposite, there is a civil code applicable in Serbia, that's also true, or at least I would say almost true. How is it possible? How can we resolve this logical puzzle? Well, we need to go back to 46 to a law, an act which had a very long title. We call it, or we refer to it in a shorter version as the law on invalidation. I was contemplating for several minutes how should I politely express my opinion about this law, and I was contemplating on phrases like, well, this law created a legal lacuna of unprecedented scales or something like that. And when I heard the formulation of my esteemed colleague, Professor Veres, that it was a law that created a legal nihilism, I think it's a perfect description of the situation, what happened. So very easily and simply, the new legal order abrogated the entire previous legal order. Well, one might say simplicity is beautiful, I agree, but too much simplicity is harmful. I think this is it was an oversimplified step and a very quick step of the legislator, which was the consequences of this move were certainly clear to the legislator, because the legislator left open the possibility of applying the rules, the content of the rules, from the previous sources of law, regardless that they are not in force, they are not in effect anymore. So if you ask me, do we have a civil code in Serbia? No, the answer is no, but we still apply it. In time, as new acts were adopted, the scope of the application of the old rules gradually shrank, but we still have some issues to which we still apply for instance, the 1844 Civil Code of Serbia. That is the revocation of donation. Contract of donation is still not regulated in our existing legislation, and the courts go back to the 1844 Civil Code. The latest case I found in the relevant databases is from 2021. To my best knowledge, our esteemed friends from Croatia and Slovenia stopped to play this game of all legal rules because by enacting new statutes, they all filled all these legal lacunas, and to my best knowledge, there is no space for application of the old legal rules. So paradoxically, it may seem, but true, we apply something which is not in force for at least 46, 2023, that's 67 years already. The Yugoslav legislation, or the Serbian civil law legislation, is there is still some form of legislation, although not in a form of a civil code. We usually call these specific acts pertaining to a given branch of the civil code as systemic laws. That is the literal translation of the term we usually use in the literature. Time and again, I use the translation of pivotal laws, which is something I really like, but then one might think that's something like in the Hungarian law, something like sarkalatos törvények in Hungarian law. Clearly, there is a difference because these laws were not enacted by special procedure, they were enacted by regular procedure, but their relevance for the legal order is of such amplitude that they were considered as systemic basic laws. And as a result of the division of the legislative competencies in 71 and 74, we have two such laws emanating from the period of Yugoslavia. This is the 78 law on obligations and the 80 law on the fundaments of property relations. I always have difficulties to translate this part of this branch of civil law, Sachenrecht. This is a compromise. Time and again, I use real right or in rem right. So this is the statute which governs the legal relations arising in relation to things. And the newer statutes, the law on inheritance and family law, were adopted later, already in the competence of Republic of Serbia. It seems that we in Serbia, and to my best knowledge, this is a unique endeavor in our region, it seems that we will try to break up with this Yugoslav tradition. That is, there was an official initiative to prepare a draft of a civil code. It was initiated already the same year in 2006 when Serbia, after almost 1 century of different adventurism in confederalism and federalism, finally again became a unitary state. The very same year, an initiative was launched to prepare a draft of a civil code. In 2007, the first report was published. That it did not contain yet any rules of normative content. In 2009, first the book 2 was published, The Law of Obligations. Well, that was not surprising at all if we take into account that the Law of Obligations, the Obligations Act, is the most successful piece of legislation in the former socialist Yugoslavia. And I try not to be biased as someone who teaches law of obligations. I try to be as much as I can objective. But generally, this is the opinion of the domestic and the foreign literature, that it is a lasting, remarkable piece of legislation from that period. Why do we say that? Because it efficiently survived 3 different states. Now I quite often make such a joke that it tramples on its 4th state, and still without any meaningful amendments. So as it was adopted, enacted in 1978, with only small amendments, it is still being applied in our country. The countries who formerly belonged to Yugoslavia, most of them already enacted new statutes, but the degree of similarity between the new statutes is very high. I think the Croatian Obligations Act shows the greatest degree of differences in comparison to the former federal statute, but still when I read the Croatian Obligations Act from 2005, I have the impression as I am reading my own law of obligations. And I'm very glad to have the opportunity to speak after the presentation on the Swiss law, because the major legislative model was the Swiss Code of Obligation. So the Swiss Code of Obligation, or the Swiss Civil Code, the Turkish Code of Obligation, and we from this region, we belong to a small but very passionate and very good working family, good functioning family of which nurtures the tradition of the Swiss Code of Obligations. After the, sorry, that was the previous slide. I need the next one. Okay, this is the next one. Okay, the next step was in 2011 when the book on family law was published. In the same year, the book on inheritance law. Interestingly, the book on general part was published almost at the end of this process. In the whole period, it was very questionable if there is a need for general part at all. So it required several years for the members of the committee to decide whether the draft of the Civil Code will contain a genuine general part or a general part of a different kind, different nature. And in the next year, that was the final step. The book on the in rem rights, the law of things, was published. These were combined in 2015. Made available to public for general opinion, and in 2019 the final version was submitted to the Ministry of Justice. So if I reshuffle this chronological order into the real order that we have in the preliminary draft, then we see a structure which will provide a great deal of satisfaction to all fans of the German Civil Code. We see a perfect pandectist structure of the preliminary draft, whereby I need to add that the general part is also extremely, if I may say so, BGB-like. So if one reads the general part, there is a clear idea behind the general part that the committee had in view the need to create abstract rules which would be applicable to all specific areas of civil law. It's quite lengthy to our taste, at least to say so, and it contains a great number of definitions from which some of really textbook-like nature. Today we heard some very inspiring thoughts about the role of definitions in civil code. I agree that all civil codes need to contain some sort of definitions, but we may argue whether all definitions are adequate or really needed in a civil code. For instance, we have a definition in this preliminary draft of something which I have translated to English as the notion of the civil law subjective right. That's, I don't know whether it's a proper translation. What I had in mind is the German Das privatrechtliche subjektive Recht. That's something we have defined in the civil code. We may argue whether it is required to have a definition of such kind in a civil code. There's a definition of thing, various divisions of things, consumable, non-consumable, tangible, intangible, and so on and so forth. What is the most remarkable novelty proposed by the Civil Code is the introduction of euthanasia or assisted suicide or mercy death. It is not surprising that this was the rule, or this was the text in the textbook, also in the Civil Code, in the draft of the Civil Code, which was heavily criticized in the public opinion. There are many opponents of this attitude, but logically it's coherent, as the supreme personal right is the right to human dignity. And if we place human dignity as the supreme personal right, then it seems logical to have a possibility to waive that right. And this is how it is theoretically and doctrinally placed, the idea of euthanasia into the text of a civil code. The second part relies predominantly on the 78 law on obligations, which was preceded almost by 10 years by a masterpiece of Professor Mihailo Konstantinovich. He was one of the greatest civil law scholars in our legal history, especially in the second part of the 20th century. And he, in 1969, prepared a complete, full-fledged draft of a code of obligations, which he modestly called only as a draft, or literally only a sketch. I don't know whether there is a better translation of the word skizza. It's something we write in hurry, only to sketching some important things. But it was not a mere sketch. It was a full-fledged complete text of Code of Obligations, from which the 78 Code of Law of Obligations diverged only to some institutions, some legal institutions. Later on, the literature, all these deviations from the 1969 draft or sketch assessed as a negative, as a turn in the wrong direction. And these major novelties, which are now proposed in the Book 2 of the preliminary draft, in the most part take into account or are influenced by the solutions offered by Professor Mihailo Konstantinovich already in 1969. Only to name them, not to explain them in detail, because for that I definitely do not have enough time. There will be some changes concerning the general confines of freedom of contract. We have a very delicate amalgam of law de république from Article 6 of the French Civil Code and combination of gute Sitten from the German Civil Code. This will be modified with moral rules, especially indicated as a specific confine of the freedom of contract. The rules on the pre-contract negotiations will be changed on lesion, usurious contracts. Repudiation of contracts, that's a very interesting issue. In 1969, Professor Konstantinovich proposed to adopt the notion of fundamental breach of contract from the Convention of International Sale of Goods. That was not accepted at that time, and now it is an idea to use the concept of fundamental breach of contract, which legitimizes the repudiation of a contract. In the subject matter of tort law, the notion of fault would be more precisely defined. There is something which is very required, the so-called objectivization of moral damage. And in this respect, the Croatian law of obligation is one of the examples. That is the most, I believe, most advanced novelty in the Croatian law of obligation. Then the inheritability of the claim of the compensation for damages, that was also differently regulated with major problems in practical application. These are to be redressed or addressed in the civil code if it will be accepted or enacted. Concerning law of things, only in short, in few words, because I'm losing time every second in my presentation. The basic rules are taken over from the 1980 law on the basis of proprietary legal relations or in rem legal relations. We should definitely have in mind that in the socialist era, the law of the real rights, the law of things, the in rem rights, were always considered a sort of stepchild of the legislation, because in a well-functioning socialism, all major assets are in state ownership. So there is no need for developed, nuanced rules of real rights, because there are not, the major assets are not in the property of private individuals, but in the property of state. So this attitude towards the real rights in the socialist period, or the legislation of the socialist period, can be traced back to its beginnings. It was always under-regulated to this reason. The major changes can be connected to year 2003 and 2005, when we profoundly modified the rules of real rights. And these special statutes and the former system law, the 1980 law on the basis of property law legal relations, should be combined into the book 3 of the draft. The next book, the book 4, is dedicated to the subject matter of family law. Mostly the rules of the effective 2005 Family Law Act should be integrated into the text of the Civil Code, but there are many novelties, very important novelties proposed by the draft. I would like to draw attention to 3 of them, which I personally consider the most important. There is an idea to legally regulate the surrogate motherhood. It's a very sensitive issue, because everything we know about the 2,000 years old legal presumptions of mater semper and pater est will lose their meaning, or should be rephrased in order to accommodate the fact that the woman who gives birth to a child is not biologically considered mother. So I don't know whether this novelty would bring more good than harm, because many other rules should be also fundamentally reformulated. Very important thing, it's one of the most important things in relation to the institution of surrogate motherhood, is whether it can be instituted by an onerous contract, or it must be always a gratuitous transaction, because when it is an onerous transaction, then it opens the door to some abuses. Well, some delicate balance is found in the preliminary draft. The contract can be onerous, not only gratuitous, but all form of remuneration paid to the surrogate mother must be moderate, which leaves, again, the possibility of interpreting what moderate actually in a given case mean. The other novelty which is expected is the regulation of same-sex partnerships in the Serbian law. For the time being, we have a situation for which I personally feel a little bit ashamed, because we are lagging behind. At the moment, we do not have any legal form which would accommodate lasting unions of same-sex partners. What does it mean? According to the Constitution and the effective family law, marriage can be concluded only by one man and only by one woman. Sadly, that was a joke. But definitely it is a heterosexual lasting union between one male and one female. Similarly, the de facto partnership or non-marital cohabitation, I don't know whether this is a proper terminology. This is something which exists in family law for a very long time, is also devised in our law as a lasting community between a male and a female. So at the moment there is no regulated form, institution which should accommodate lasting union, lasting partnerships of same-sex partners. That's a challenge because we know from 2015, from the case decided by the European Courts of Human Rights, the Ordinary and others, that some form of lasting union, legally recognized lasting union, should exist for same-sex partners, because otherwise it's the infringement of right to private life and right to family life. So a solution should be found. One of the solutions is proposed by the draft. The draft intends to extend the notion of de facto partnership to any form of lasting union, regardless whether it is a lasting union between same-sex partners or heterosexual partners. The other solution is the introduction of so-called registered partnerships only for same-sex partners, and there is a draft already prepared, but for some political reasons it has not been adopted yet. The third institution, which I also consider quite important, is in the matter of family law, is the introduction of the so-called children's alimony funds. There are great difficulties in collecting alimonies in different legal situations, which are especially painful when it comes to the alimony which to be paid to children. So when the children are in the position of alimony creditors and the alimony is not paid properly, then this causes significant social problems. One of the reasons is to introduce alimony funds which would socialize these obligations in a certain time. Of course, later on, the alimony fund would have a recourse right to the alimony debtor, but definitely that would improve the efficacy of the collecting of alimonies. I have problems with time, okay? Oh, one more slide. And only in short, the least novelties are expected in the matter of inheritance law. There are some novelties, but the inheritance law is traditionally considered as a stable branch of civil law. But there are still some novelties which require our attention. First, the contract on succession are proposed to be introduced. At the moment, we have only two grounds of inheritance, statute and the last will, the testament. The third ground, the succession contract or contract succession, is proposed to be introduced. At the same time, the contract on lifelong maintenance between spouses should be forbidden. And the last thing to which I would like to share, to shed some light, is the intention to change the traditional concept of nasciturus, which creates a fiction. This is the way, at least I teach it to my students. The only fiction we have today in our law is the nasciturus fiction. All other fictions are either rebuttable or very occasionally or almost never irrebuttable presumptions. So we really rarely have fictions. One of the fictions that still survived is the nasciturus fiction, and there is a great change in this matter which is expected. Traditionally, the nasciturus fiction means that the child must be at least conceived at the time of the death of the testator or the devisor. The new concept proposed by the draft is that it is not a requirement that the child is already conceived at the time of the death of the testator. It may be born later on. It opens the way for the application of modern techniques of biomedically assisted reproduction when their germ cells freeze or leave it for some time in the future. And that might open the possibility for a child which is born after the death of the divisor to inherit something. That's a noble idea, at the first glance, interesting idea, but definitely a time limit is required, because if we leave open this risk of inheriting after the death of the divisor, then a great deal of legal insecurity or uncertainty will be at hand. Dear esteemed guests, it was my short presentation about the draft of the Serbian Civil Code. I'm thankful for your attention.